Okay, we're live now. All right, this is the Good Fight with attorneys Steve and Josh. Today we're going to change it up a little bit. We're going to focus on a different area of the law that we practice here, which is family law. And today we're going to talk specifically about a custody proceeding or paternity action, which is a case where parties were not married but have kids, and so the difference really being that there's no division of property. There's no property rights at issue. It's just the custody and visitation issues that arise when parents do not get married and have kids that they love and want to make sure their best interests are always met. Okay, so today we're going to talk about a PPA, which is a parenting plan assessment, and they're commonly referred to as PPA 1 or PPA 2. The main difference really only being that PPA 1 is a one-day evaluation by a therapist, usually a court, an employee of the court. PPA 2 being a two-day process or a two-day evaluation, and we really don't see PPA 2s. But they are used when the issues are very, very complex, and probably when the evaluator or the court is interested in interviewing a lot of people, a lot of witnesses. Maybe there's some sexual abuse going on, something like that, and so the court needs to hear from a lot of people, and it can't get done in one day. But of course, we're used to seeing a lot of PPA 1s where the evaluator will interview obviously mom, dad, the children involved, and maybe any other family members involved too. Maybe the kids live with grandma, grandpa, that kind of a thing. And so today we're going to talk about a hypothetical situation where you have a couple that wasn't married, obviously, have one child. Let's assume a 14-year-old boy who has just started high school. He's a freshman, and so we're going to get also into a little bit of the law in terms of what a judgment is, and in this hypothetical there was a judgment, so different standards apply when one party is seeking to modify a judgment. Okay, and in this case assume also a judgment of 5 years ago, where the parties agreed to share joint legal, but mom to have sole physical. And so we're not going to get today into this, in this podcast, we're not going to get into the difference between the two. But for now, it's sufficient only to know that mom has sole physical, and now dad, for reasons that we'll get into in a moment here, is now seeking to modify the judgment so that the parties have joint physical and to modify visitation. Okay, I also want you to let's assume also that dad is involved in a gang, and so we're going to assume that too. So first, let's talk about what family code section or what legal authority exists for a PPA 1 and what it says, Josh.
So, Family Code 3111 is the authority for what's commonly known as a PPA. I don't want to butcher it, so I'm going to bring it up.
Sure.
Section A says, in any contested proceeding involving child custody or visitation rights, the court may appoint a child custody evaluator to conduct a child custody evaluation in cases where the court determines it is in the best interest of the child. And it goes on to talk a little bit more about that, but essentially what it comes down to is these family law cases are tough because the judge sees just a small snippet of the soap opera that is the case, right? And it doesn't matter how simple the case is, there's a soap opera involved in it. And so PPAs are used when there needs to be more information, and the court needs somebody that is trusted, that is neutral, that has the credentials to evaluate the situation and make unbiased recommendations, such as this, right? You have a child who is in a stage of his life where you could not be more of a sponge, right? You're a reflection of the people that have raised you, and you're a reflection of the people that you associate with at the age of 14. And you're talking about making big life decisions in the next few years and determining where or if you go to college and how you're going to live your life. So in a situation like this, it's the ideal situation for a PPA, right? The judge can't come down off the bench and interview these parties. An evaluator can. And so she's going to get in a room with all of them separately, and she's going to ask the questions that need to be asked and make her recommendation to the court. And because the court can't come down off the bench and ask those questions, they put a lot of weight in these evaluators' reports.
Okay. And so assume for a moment also that you have, again, a 14-year-old boy and who maybe has a desire to want to spend more time with dad. Assume also that dad, let's say, has visitation with the 14-year-old son every other weekend and a midweek visit. Okay, so assume those facts too.
Okay, so let's talk about two different scenarios here. Let's talk about that scenario generally, and then we'll talk about that scenario with these specific facts. So generally, it creates quite a conundrum, right? Because we're on both sides of this pretty often. You have one parent who there's not really a reason that they shouldn't have 50-50 custody, right? There's no history of abuse or anything like that. So now you have a parent who wants to, for whatever reason, right, have a more fulfilled relationship with their son or daughter.
Okay.
And so it creates this situation where what are we really doing here by fighting the additional time with that parent, right? If the public policy is in favor and the statistics show that there should be frequent and continuing contact with both parents and that it's in the benefit of the child to have a relationship with both parents, then what are we really doing by fighting the additional time? Now, the arguments are that, the need for stability and continuity are just as important as the need for a relationship with both parents.
Talking about status quo?
Exactly. You don't want to disrupt what these children have been accustomed to.
Right.
Okay. It's interesting. At the same time, in this specific situation, right, it's a little bit different because although this person may want to have that additional time in relationship with the son or the daughter, there's extenuating circumstances here, right? You have every time this child is put in the hands of the father here, right? He's been put in the hands of danger because of his history with gang members. Right.
And so let's talk a little bit about that though, because assume also that dad loves his son very much and is the kind of dad that is not going to put necessarily son in a situation where there's criminal activities going on. Okay, so really what we're talking about is this milieu of the son getting marinated, for lack of a better word, or embroiled in this culture, in this lifestyle, in this one of the things that I really don't like about our justice system is that courts and judges and politicians even and the legislature really don't act on things until it's too late, until it's already happened, right? So there isn't a lot of this prophylactic or preventative decisions where, let's talk about the courts here, right? By these judges, these family law judges who really don't want to act before something happens, okay? And I have a problem with that because, when you have cases like this one, for example, where the writing is on the wall and the evidence that we can present, that we do present, it is, in my opinion, sufficient enough to, maybe even beyond a reasonable doubt, show that a particular individual is just not I don't want to say fit to be a parent, because that's not what I'm trying to say here, but not fit to make the right choices to make sure that their kid is going to end up to be a successful or just a good person in life, someone that's going to be successful, someone who's going to thrive and do well in school and turn out to be a thriving member of our community.
I agree, right, to some extent. I think that my issue here is that if you're going to allow the child to be around him sometimes, okay, then really what's the difference? Right? If you're saying that he's safe to be around, and by safe I mean he's able to make decisions for the child, right? He's able to impact the child's life every other weekend, then isn't that you also saying that he's basically good enough to be a parent, right? That's what we're really saying here. And so I think that's where I have an issue with the argument that he shouldn't have more time in this situation, or in any situation. A parent shouldn't have more time because they're not fit to make the decisions, but yet they still have every other weekend and a weeknight visitation, right? So are they safe or are they unsafe, right? It's binary in my mind. Mm-hmm. They're either fit to be a parent or they're not fit to be a parent. I don't know, right? Yeah. There are obviously other circumstances and criteria that go into it. Look, he may be fit to be a parent, but his schedule just doesn't allow him to get the child where the child needs to be. That's one circumstance where I could see that, right? Yeah. But I don't know. It's I think that's what is lost a lot of time in family law is that, and I think both judges and attorneys are guilty of it, is that we deal with the soap opera, and the soap opera wears on us. And so the court is trying to make decisions to get it off of their docket. We're trying to make decisions to get it off of our plates. And I think what's lost is that these people have to live with these decisions every single day of their life. And so...
Good point.
I think the PPA is a good tool to bridge that gap between the judge that wants to get the case off his docket, the attorney that wants to move on to the next case, that can't afford not to move on to the next case, right? And the families that have to live with these decisions. By using a PPA evaluator, you're using a tool to make sure that the decisions that are being made are going to positively impact these people's lives on a daily basis.
Yeah. Going back to what you were saying about, this being a sort of a binary analysis where, what is the parent, in this case, the parent that's trying to not have the dad exercise more visitation, and sort of it being a factor of, hey, is he a good parent or is he not a good parent? Because if you're saying he's good enough to have, some visitation, well, what's wrong with him having a little bit more, right? But again, let's go back to this, and I agree with everything you're saying, but let's go back to the crux of this hypothetical, which is that you have dad who's, and there's no dispute about it, he's involved in a gang. Okay, he's involved in a gang who's known to engage in criminal activities and illegal things and who knows what else. And so I think that here, that really is the dispositive factor because, like I said earlier, we're dealing with a situation where this 14-year-old boy is in a very formative stage of his life, right? Identity and his social identity are being developed, right? I mean, I can remember when I was a freshman in high school, and that's exactly where I was at in my life. I was like, I was into punk rock music, and I was dressing like a skater and a punk rocker, and and who I hung out with is extremely crucial. It's vital, and it helped shape, the person that I am today. I still like punk rock music, but that's not the point. The point is that when you're at such a young age, who you hang out with is going to make a life-lasting effect on you, right? And so if this father is awarded more time by the court, then the likelihood of this 14-year-old boy spending more time with, thugs, let's just call it that, and this type of culture and this lifestyle, then there's a higher likelihood that he's going to turn out to be someone like that. So, I mean, I see what you're saying about he's either a good parent or he's not a good parent, but here there's something a little more, and that something a little more is very dispositive.
Yeah, and I agree with that. I think that these are obviously, facts that we don't necessarily deal with on a case on a casely basis, if that's
Right.
a word. I think that it's interesting in this case specifically that there's no denial of being involved with this gang. There's almost a sense of pride in being a part of the gang and that culture. And I think that for a judge and hopefully for an evaluator, that's alarming.
Right.
Because it would be one thing if mom or dad, whoever was involved in the gang, said, this is who I was. I have a child now. This isn't who I want to be anymore. I'm going to make sure that I'm not part of this culture anymore. But that's not the case here.
Right.
The case is the opposite. The case is,
point.
this is who I am.
Right.
And regardless of who I am, I should still be able to have my child. Well, that's not how I see it, right? And I don't think that's how the courts should see it either. It's the court and the state has a duty to protect the children.
Right.
Okay? And if they're knowingly giving additional time to a gang member who has no issue with what he does and how he conducts his life, then isn't that just the court saying we're okay with putting children into gang culture, inserting children into gang culture?
Right.
What's the difference?
Exactly. And good. I'm glad we're talking about this now, because the next thing that I want to talk about is, we are advocates, right? And we don't represent the minor child. And in family law, there are a lot of situations where the court will appoint a specific attorney for the children, but that's not this case. That's not the hypothetical. We represent a certain individual. And in this case, let's assume that we represent the mother in this case. So, do you believe that there are other tools available to us as advocates for mom, right? And to a large degree, advocates for the child, because we've been talking about that, right? But we're not specifically, the attorney for the minor. But my point is, are there other tools that are available that we should potentially be looking at in terms of, right? We're talking about evidence. We're talking about getting the court the information that the judge feels the judge is going to need to make the right call, whatever that means, right? So discovery, subpoena power, these kinds of things, depositions. What other facts are out there that we need to be looking at so that we come time for the hearing, the court is informed and has a full picture?
I don't know how much discovery and depositions and the subpoena power are going to get you in a case like this, right? Because you're dealing with somebody that is not going to be truthful, right? And so discovery is helpful when you're dealing with people that have somewhat of a moral compass. Okay, that's not this person, and so I think maybe the other tool here is, CPS, right? In that, look, Your Honor, if you're inclined to make a decision to put the child in this house more often, then CPS needs to be given the ability to stop by when they need to, right? And do pop-ins. Or before the child is going to live in this house, right? CPS is going to stop by and see what's going on, right? I don't know. You're talking about a very well-known gang here, right? And so discovery, I don't think it's realistic.
Okay. What about a deposition? What about a deposition of dad and asking some of these questions? I don't know. Are you a known member of such and such gang? Yes, I am.
Well, I think it's already been stated on the record, though, in this case specifically. Yeah, but if we're talking generally, then and you're looking for that, I don't think that there's an issue with sending RFAs.
Yeah, exactly. Right. And RFAs you're talking about requests for admissions.
Yeah, and so you send RFAs, and then at an RFO or at trial, if it gets that far, you put them on the stand and If you have the essential impeachment documents, then there's no problem with it.
Well, let's talk a little bit about that, because that's an interesting topic as it relates to, credibility, of course, because that's always at issue. But, when the PPA comes, in other words, when the court evaluator talks to the parties, I think it's important that that individual have the necessary information already ready to go, right? And in other words, it's almost like we need to, as advocates, make sure that the evaluator has all of the facts about that culture, about this person's involvement in that culture first, before it. I certainly wouldn't want that to be something that takes up, because again, it's a very limited, it's only in the morning. It's from 8:30 to about really 1:30, and then at 1:30 p.m. is when the hearing is with the judge. So there's a very finite amount of time in which the evaluator has to conduct the analysis.
Well, and we're not given the opportunity to talk to the evaluator during this process.
We're not, only after.
And so we just have to be armed with the facts, so that if we do not agree with the evaluator's report and we put her on the stand, right, we need to be able to give her the scenarios and ask her how her analysis would change given those scenarios, right? Given the facts that she may or may not have been privy to.
Yeah.
Right? I don't see another way. That's the only time that we get to ask those sorts of questions to this evaluator.
Right. It's a direct examination.
Because if we asked him anywhere else, it'd essentially be ex parte communications.
Right. So for the question on cross would be something like, Mr. or Mrs. So-and-so, when you formed your, and let's assume that it would be a recommendation that's contrary to what our client wants, right? So on cross, it would be something like, when you made your recommendation, did you know, or did you base your decision based on these set of facts? Or were you given these particular set of facts prior to you making your determination, your recommendation?
And it's interesting that you use the term cross-examination, and I don't think that it begins as a cross-examination. I think it almost begins as a direct examination, because we want to know the reasoning behind some of the things that he or she determined. And then once that reasoning comes out, if it's not sound, or if it's outlandish or something like that, then I think it turns into a cross-examination of her logic, really, right, and her moral compass in a situation like this.
Right.
There's no reason to turn somebody into a hostile witness if it's not necessary. I would like to believe that these people are doing the best that they can do, right, and that they're looking out for the child's best interest. And so I think that it's necessary to almost conduct it as a direct examination and get all the logic and the reasoning out of her or him before going in on cross-examination, because it'll give you a better idea of where she's coming from and why she's doing it, and then you'll be able to provide her with whatever facts are necessary on cross, right, and give her the necessary hypotheticals. But if we don't know why she came to the determination that she came to, and we just go aggressively at her right away, we may be missing things that we're not aware of.
Okay, I understand your point, and I agree with it. We're blessed with also being able to do personal injury law, and of course we've had the privilege of conducting voir dire with jurors, right? And and when we do that, and the court will admonish them as well that they're allowed to bring their past experiences and life experiences to the courtroom, right? But in our quest to find an entirely impartial panel, they are asked of us, the lawyers and the court, to put that aside for a moment and to judge the case only on the facts. You know very well what I'm talking about, right, Josh? And so in family law, and in this context, do you think that same obligation really exists when it comes to the judges, and in this case an evaluator, as it relates to maybe some of the things, because they see it all the gang culture maybe not, but sort of this soap opera.
Well, I think it
you
depends.
know,
I think
so,
it depends on the gang culture specifically. It depends on what courthouse you're at, right? Because I guarantee you, when you're in downtown LA or in Compton or something like that, I guarantee you they deal with this pretty often.
Right.
Right. If somebody has the means to get into court.
But family law courts are not criminal courts,
right,
either.
Right.
Okay.
I think that, well, first of all, I think the law says that they have to be impartial, right? That's a requirement for a for a 3111 evaluator. They have to be impartial.
Right.
Okay. There's supporting case law that says that, and so if what you're asking is that a line of questioning that you need to go into in order to make sure that this person is free of bias? I mean, maybe.
Right.
Maybe. I don't know, right? I think that you have to have a backup plan to the backup plan, and if, on direct some stuff comes out that we're not happy with and then we're not able to cross it like we would like to, then I think at some point, her background or his background and credibility has to come into question. Right? Is there a reason that she's making this? If the logic doesn't make any sense and she's dodging questions and she's wiggling on the stand for what should be no apparent reason because she's supposed to be fair and impartial, right? Then I think that it absolutely comes into question.
I think that I would fear. I think the fear would be that the relevant or one of the relevant analysis for the court and for sure for the evaluator is going to be. And you've talked about this before, which is, how long has dad been in this culture? How long has the minor child, been with dad, right? Let's assume since birth. Okay, how long, right? So then it becomes and I've talked about it too, which is my sort of dislike of the justice system, which is we have to wait and see. There has to be some bad event first before I can actually intervene. And I disagree with that. I think that we are, and especially in a case like this where we're asking the court to intervene now, to intervene at the most crucial moment in this young man's life.
I mean, look, I think it comes down to one very simple question, right? And that is, in what world, right? By what logic would it be okay to put a child in a gang?
Exactly.
Right? What would be the logic here that this is a better situation than what he's currently in? Right? Because the standard here, right, a significant change in circumstance, right? That's what has to happen post-judgment modification.
Right.
Okay. The modification has to be so paramount to the child's well-being that it would be against his best interest not to implement it.
Right, exactly.
How could this in any situation be against the child's best interest to not, or how could it be in the child's best interest
yeah, exactly,
to insert him into this situation more often?
Right.
In what world?
Exactly. Yeah, no, you said it best. I think, I think we have now a good North Star to pursue. Okay? All right. Well, we're just about right out of time here, and a good moment to end our second podcast. Thanks for joining us. Next time we will see you and talk about some, maybe we'll talk about bankruptcy law a little bit.
That's all you.
Yeah. All right. Thanks for joining us.